here with Mr. Jonathan Tisher of Tisher Liner FC Law. Tisher Liner FC Law is a law firm based here in the Melbourne CBD, been around for 45 years with 60 people in your firm. The customers that I have that use your firm have been second generation customers of yours, so the children who are now taking over family assets are continuing with your legal advice. In my experience, dealing with your firm and your lawyers has been practical, efficient, and just easy to deal with. So I thought it was a great opportunity to talk to you, giving a bit of clarity as what the hell is going on here. Hopefully through this interview we can put some clarity for viewers of best way forward and how to ensure that they're able to minimize any losses and just maximize any certainty in this very uncertain time. Has the sacred seal of contracts been broken now with all of these changes in relation to the code of conduct?
I think it has. I think the reality is that a contract, or people take the view, a lot of tenants take the view that a contract is there, but if the circumstances aren't great in the world, and they aren't at the moment, they're just going to breach it. And it's harder for a landlord to take them on, to enforce it, because to get to court, to get to VCAT, plus there's the protection, some protection of the regulations, it's just much harder to enforce.
So for all those watching this now, can you run us through the Code of Conduct 101?
Yep.
So what are the need to knows for a landlord and a tenant, and who's affected and how can they work around it?
So the first step was the Code of Conduct, and the Code of Conduct was set by the federal government, and it was a statement which set out effectively a proportionality test. So if you are a business with an SME business with a turnover of 50 million.
SME, small, medium
enterprise, correct. And your turnover has dropped by more than 30%, and your turnover has to be less than 50 million, then the Code of Conduct applies. And basically they apply what's called a proportionality test. So if your turnover has dropped by 40%, then you are entitled to a 40% rent reduction, of which 20% can be waived, 20% to be deferred.
What if your turnover fell by 100%?
So if your turnover fell by 100%, then 100% of the rent is 50% waived and 50% is deferred, which means you pay no rent for a period of time. And the period of time is set to, was the period of JobKeeper, which was to the end of September, and there's now been talk about changes to that and extending that. But that's effectively how it operated. And it provided that in order to have effect, then the Victorian or each state had to then implement their own legislation, and that then governed what happened in the state. And the next step that happened was the Victorian government implemented specific COVID-19 legislation and then regulations which applied to leases, and took a slightly different view.
So is your entire day absorbed with Code of Conduct negotiations?
A great part of my day is absorbed in those sort of negotiations, and they're constantly changing because you think things are getting better, and then suddenly the environment changes and tenants want to go back and renegotiate. So an example would be a client emails me and says, can you document that we've agreed to give for 3 months 40% rent waiver and 40% rent deferral. And then after 3 months we've agreed that it's not continuing anymore. And
back to full rent.
Back to full rent. And I document it. And by the time I document it and send it to the client, that might take 24 hours. It might take, and the client will look at it and come back to me.
That's a good turnaround for a lawyer.
Thank you. Perhaps the whole process takes 2, maybe 3 days by the time there's feedback from the client. The client says to me, no, the situation's changed. I've sent it to the client, I've sent it to the tenant, and the tenant's a bit worried about the environment and wants longer. And we go back and renegotiate.
And that just keeps going.
And it keeps going. And it's happening fairly regularly. And the legislation allows a tenant to actually go back and renegotiate a deal.
And of all the examples of you negotiating Code of Conduct, can you, without mentioning names and details, can you talk us through the best outcome you've seen so far and maybe the not such best outcome?
So often the best arrangements is where the tenant contacts the landlord directly and the landlord and tenant pick up the phone and they do a deal over the phone quickly. The landlord doesn't put onerous requirements on the tenant to provide all this information. There's a long relationship there. The landlord wants to see the tenant up and running. The tenant provides some information. It may not be audited statements. And if they do a deal, it's documented and they move on. And there's a bit of give and take. The worst transactions, and it's often the larger entities that do this, is they simply say, this is what we're doing and we're not going to talk to you. And they're actually often, those big companies, and you can see it, it's in the paper, those sort of entities, they're actually not complying enterprises. They don't fall within the legislation.
They're not SMEs.
They're not SMEs. They're not within the $50 million turnover. They're above it. And they simply say they certainly don't fall within the Victorian legislation. They argue that they fall under the code, And the reality is that they don't, but they think there's an argument. And there's a little bit of greyness there, and they simply don't pay.
And is that story still unfolding in front of us?
Absolutely.
What do you think is going to happen?
I think ultimately, so you have these major tenants, major tenants that write to landlords and say, we are not going to be paying rent. We will give you a percentage of our turnover, and that's what we're going to do until this issue resolves itself. You've got a contract on foot, a lease, which they don't comply with. They don't comply with the Victorian legislation. They often don't give any information about their enterprise. And what's going to happen is, I think some landlords will ultimately take these tenants to VCAT.
Have you seen that happen yet?
So I've seen landlords take tenants to the SBC for remediation. It's a very slow process. I've had one where we've had one mediation which went through relatively quickly, but they've been bombarded with applications. So it's very, very slow. You can wait 6 to 8 weeks to even get a call back.
So with all these cases just piling up, how is the court system going to deal with it?
Yeah, well, that's the incentive for a landlord and tenant to do a deal, because this can go on for a long period of time, and I don't know how that they will unless they put more people on the courts and VCAT to address it. I actually don't know how they're going to cope with the volume of cases that will come through.
Considering the circumstances and the speed in which this legislation was written, in your opinion, do you think they've done a good job with it?
They had to do something. You had a pandemic where you had an enormous amount of tenants in the industry just unable to pay rent, businesses closing down. So if they did nothing, landlords could simply issue a notice of default and shut premises down. So they had to do something. Is it perfect? And there's differences between the states and the code. Time will tell.
So you thought it was appropriate for the government to get involved between landlords and tenants relationships?
Absolutely. The government had to do something. Whether what they've done is perfect, time will tell. I think there's issues on some of the wording within the code of conduct. I think there's some ambiguities within it.
Anything stands out?
To me, it's probably more the biggest issue is that the code of conduct is a straight proportionality test, and the legislation, particularly in Victoria, takes into account the landlord's circumstances. So if the landlord has a mortgage, as an example, they need to be able to pay their mortgage. So where do the two of those fit? Now, the reality is, if you're a Victorian tenant, you have to comply with the Victorian legislation. But when a tenant's arguing a point, they go back to the code. And even though the argument is, well, it's not binding, you end up in this argument.
That's a good question, which I was going to bring up. In the code, there's a clause there that talks about taking the landlord's financial situation into consideration when negotiating.
Yeah.
You would have negotiated tens, hundreds of cases so far as a firm?
Be hundreds.
Hundreds. Have you ever seen any instances where the landlord's financial situation was taken into consideration?
Yeah, on almost every matter where I'm acting for a landlord, we put that to the tenant. So when an offer is put to us, so if I'm doing the negotiation, then we put that to the tenant and say, look, it's not a straight proportionality outcome, which is what they put. You need to take into account that the landlord's got a mortgage, they have to service the mortgage. Perhaps there's been rent relief provided relatively recently. Perhaps the landlord's done some works at the premises and the landlord's expended money on the premises. So all of those things need to be taken into account, and instead of giving 40% based on straight proportionality, the landlord's going to offer 30%. It becomes a negotiation.
And has that worked successfully for you?
To a degree, you might. The reality is, those people that want to do a deal reach agreement. Once there are lawyers involved on both sides, it's harder. Yeah. Because the tenant briefs a lawyer, the landlord has a lawyer, there's then that layer of costs. Like I said, the best deals are the quick ones done between the landlords and tenant.
By themselves, without any outside
I think
advice?
So. Yeah, a landlord might pick up the phone. A lot of them, a landlord will pick up the phone and say to me, look, this is where it's at, what do you think? What else can I ask for? And I said, look, you can ask for all of this, and you can seek all of this, and this is what it says. But if it's close enough or near enough, let's just document it and put it to bed. Maybe push a little bit more. And with the tenant, same thing. So all those sorts of things, you give them guiding principles. If you go to the letter of the law and do everything that's required, you can just end a negotiation very quickly.
With hundreds of cases that your firm has been involved in, are you seeing any consistencies between private landlords and institutional landlords in the way they're going about this?
I think most private commercial landlords that I've dealt with are very hands-on. They deal directly with the tenants, they get on the front foot, they try and put a deal together quickly, efficiently, document it and move on, and they're responsive. Institutional, it depends really whether there's someone really who's taken charge. If there's in-house legal that's doing it, it can be a little bit more cumbersome. If there's someone who's very hands-on within that institutional entity, then it moves more quickly.
What if you're a national retailer that has stores across all 5 states or across Australia? Which code of conduct do they fall under?
Yeah, so the lease that you're governed by usually says you're governed by the laws of Victoria or the laws of New South Wales, and that's based on where the premises are. So if it's a major retailer, national retailer, and they have property or they're leasing property within Victoria, they're based on the COVID-19 Victorian legislation.
So they can have 5 different situations all around the country.
Correct, but they will argue, a lot of them do argue, well, first of all, they don't fit within the COVID-19, so they don't fit within the legislation. So they're actually not entitled to rent relief. So what they do is they say, well, no, the code of conduct, which doesn't actually give them that right as well, has a passing sentence in it which gives them an argument, and they just rely on that.
Now, there's situations where people rent retail spaces, but they actually don't generate any income out of that tenancy. For instance, it's a showroom, or it's an office space, or a display suite, or even branding, signage branding. The revenue doesn't go up and doesn't go down. In those situations, are they entitled to any rent relief?
Yeah, so the Victorian legislation covers basically retail and commercial leases. So you would argue they're commercial leases, so they can seek rent relief.
So you can change one thing about the retail market. What would that be?
I think there's quite a lot of ambiguity in the legislation, and if it was a little bit clearer and there were very clear parameters, I think it would give more certainty. So if we could fix that, I think the reality is people want to do a deal, move on. This is going to pass. We all know it's going to pass. We're going through a pretty difficult period, but there will be positives that come out of this. So if we can just get through this, do the deals, document it, accept the fact that tenants deserve some rent relief, provide the rent relief, but do it in an appropriate manner so that it's reasonable and fair. And then the reality is we want long-term relationships with our tenants that work. They want to be there running a profitable business, and we just have to get through this together.
When you say there's positives coming out of this, can you elaborate?
Well, I think there'll be some incredible deals that can be done on floor space, on retail, shops, on commercial, offices, and all those sorts of things. There'll be a lot of space available, and I think landlords will have some really great deals, and there'll be some incredible opportunities for tenants. And the reality is businesses will improve. The reality is lockdown will pass, and we will move to a position where businesses are flourishing again. So, if both parties are commercial and practical about it, fantastic opportunities in the future.
And on this code of conduct situation, is that both retail and office, are they treated the same?
It's retail and commercial. So if you fit within the argument of commercial, then yes, you are.
So it's one rule fits both categories?
Correct. So in terms of what advice would I give to landlords and tenants, the advice I would be is be practical, be commercial, and don't be overly pedantic. You can get caught up on the details here. Whether you're giving 30 or 35% rent relief, the difference might be $5,000, $10,000. In the scheme of things, the reality is that it's best to do a deal, to document it. Obviously, you're not going to give up everything, and same, this works both ways. But to me, you can kill a deal by being overly pedantic, by asking for more and more information and sticking to every single requirement under the legislation. Usually you know how the tenant's business is tracking. You can see they're struggling. They may be asking for more than they're entitled to, because a lot of tenants are doing that. And certainly that should be corrected, but you're never going to hit the exact percentage that they're entitled to from both the landlord and a tenant's perspective. So there's a little bit of, there's a lot of commerciality to this. You've got to just be open and transparent, and don't overly complicate it, in my view. Get the deal done, take a long-term perspective, document it. Certainly don't give away what you shouldn't, but document it and move on. Because if you can keep that long-term relationship with your tenant, that's a good thing. The reality is when this is all said and done, there's going to be a lot of vacancies out there, and tenants are going to have options. So put the deal together. Tenants don't want to move. They've usually established a business, so they don't want to move. So work with them and find a solution.
We're seeing that a lot of landlords taking on the view that this is a few months in a 10-year lease. And yes, it's a bit of a bumpy few months, granted, but if we work together, we can get back on track and finish our 10-year lease, as opposed to starting again. And the costs of reletting in a good or bad market is pretty high and pretty unknown. And as Michael Schreiber from FunLab said, he said, the grass is always greener on the other side because there's so much shit on the other side.
I couldn't agree with you more. The reality is, you know, it is a bumpy ride. If you can get through it, do a deal. Obviously, you have to be commercial about it. Obviously, you have to look at the turnover, and some turnovers do push, some tenants do push the point. But the reality is that if you can put it to bed in a pretty practical and commercial manner, that's not going to, that from a long-term perspective is okay and you can live with it, move on.
And this is the same advice you give to both landlords and to tenants?
I give the same advice to landlords and tenants. It's really...
Because you represent both.
I represent both all the time. I say to tenants, when they're asked for information, be transparent. Give the information. There's certain information you may not have to give, but give it, be open, show how you're suffering and ask for the rent relief. And same with the landlord. I say to a landlord, ask for this information, but do we need, you know, if a tenant provides this information, do we also need audited statements and this and that? Sorry, I'll go back to that. Basically, I take the view, if you can put the transaction to bed in a commercial manner that you can live with for a relatively short period of time, that's a good result.